everybody trying to get into our talk tonight, but we've got bells, whistles, and signals shut down, perhaps because of our speaker tonight. But thanks for coming and braving the wind, and it's always a pleasure to be in the Lyceum, isn't it? What a special place. And I'm so thankful that so many citizens rallied around this building to preserve and restore it for the bicentennial, you know, right before, prior to 1975. There's an exhibit back here that talks about it. It was really in disarray, as many of our buildings were at the time. So now as we go forward, as we're looking at the 250th anniversary, I wonder what equal projects we could come up with as citizens to recognize the importance of Alexandria and our history here. But I'm very thankful for the city of Alexandria and all of the citizens that keep the Lyceum going. My name is Pam Cressy. I'm the current president of the Alexandria Historical Society. Thank you for coming. We're an all-volunteer group. Many of you in attendance tonight have been on our board over the years, and we're now moving into, we've had our 51st anniversary, so it's our 52nd year of lectures. And none of the founders of the Historical Society, as far as I know, are around or are living even perhaps. But I want to thank them as well, that we can carry on for hopefully another 50 years and beyond. I want to particularly, wait a minute, I think I don't have the forward slides. Tonight, our speaker is John Rand, and I'm going to introduce him in a moment, and he's going to be speaking about George Mason and the 10th Amendment. I want to bring up two events that are most current coming. April 5th, which is, boy, almost here, isn't it? On Saturday, Michael Pope. Michael, can you stand up? Yes, Michael Pope, our noted author and journalist, is going to be giving a tour called Byline Old Town. He's done the research currently, so you won't be able to read about this someplace else, maybe somewhere read in one of his books along the way. And we're going to have a great tour. It won't be a lot of walking steps, basically about around a block or two, about where early journalism and printing occurred. And this is really an important topic and one that is close to Michael's heart. So I hope you'll join us. You can register on our website, and there's a different, a less expensive price for being a member. And next, the last Wednesday of the month, our April meeting, is our annual History Awards. Now, you may not think, hey, I'm not getting awards, so I'm not going to come. But this is one of our most exciting meetings a year, because we can recognize students in Alexandria high schools who are outstanding in history or in a broad range of topics and honor them for their accomplishments and interests. And we can also honor, I guess we call it non-students, adults in Alexandria that have made significant contributions. We always look for nominations, and we have a committee to develop those awards. It's really a wonderful way to say thank you to the people that are keeping history alive and moving forward in Alexandria in a variety of ways. And we will have one of our board members, Darnella McGuire-Nelson, give a rousing talk. And Darnella, could you stand up, please? Thank you very much. A member of our board, a native Alexandrian for more than one generation, and we like to say during our awards, have a speaker like, why do history? What's important? Why preserve anything? And I think it's particularly important for the students to hear. And Darnella is going to say, and you are history. And I think that's really important. And she will be hosting our tour this summer, a behind-the-scenes tour. Well, it's not exactly a tour, it's a gathering to talk about the roller rink in Alexandria, which some of you may remember. So our behind-the-scenes tours and Zooms and other Zooms with historians that we can bring in, we're increasing the number of things we can offer. So I hope you'll become a member and get the news and be able to participate. And Dave, could you tell us about Lee Fendo, please?
Good evening, everyone. Many of the board members of the Alexandria Historical Society, we are also the board members of other societies and organizations. I happen to be on the Lee Fendo House Board of Directors. And so on behalf of those Board of Directors, I'd like to event that occurs after Michael Pope's walking tour on April the 5th. We are going to commemorate the 160th anniversary of the end of that house being a Civil War hospital at the end of the war. We know that 1,700 soldiers were in that hospital. We know that 100 of them died, and we know about 52 are buried in the Alexandria National Cemetery. So at 12 noon, we're going to have a plaque laying ceremony, and we'll invite any one of you here to attend. And good news, it's free. All you got to do is register so we know how many people are coming. So thank you very much.
Thank you. So those of us that will be on Michael's tour, I think we'll be just walking over to Lee Fendel and enjoying it. It's another great Alexandria History Day. Thank you, David. And then we'll continue having our spring lecture series the last Wednesday of May and June. Then we have some summer tours and Zooms, and then again in September and October. So look for all of our different stories. Now I'd like to introduce Sandra Vieira, who is from Gunston Hall, George Mason's home, as a prelude to John's talk, and she has some goodies on the chairs for you. Sandra is in charge of marketing and public relations for Gunston Hall. And thank you very much, Sandra, for coming tonight.
Well, I've already been introduced, but I was going to say good evening. My name is Sandra Vieira, and I'm the Director of Marketing and Public Relations for George Mason's Gunston Hall. I won't take up too much of your time before the main event, because you've come here to see a talk on George Mason and the 10th Amendment by Dr. Rand. I want to thank Pam Cressy, who thoughtfully asked me to briefly present on nearby Gunston Hall to help us publicize it. I have only about 3 slides to show you. In your seats, you'll find a rack card with information about Gunston Hall and a complimentary general admissions pass for 1 person. Oh, can't hear me? Is that better? Oh, okay. Okay, closer, okay. So here is the first slide. Sorry. Here is the first slide of George Mason's Gunston Hall, and as you can see, the mission of George Mason Hall is to stimulate the exploration and understanding of the principles expressed by George Mason in his 1776 Virginia Declaration of Rights, and I'll talk about that a little bit more because the 250th anniversary of that will be coming up next year. So, let me see, down button. Here we go. All right, so on our first slide, we have a picture, the interior of the house. And the mansion was built sometime between 1755 by architect William Buckland and carver William Bernard Sears, who are basically responsible for the interiors. George Mason himself was responsible for sort of the general architectural outline of the house. We have the great parlor and the hallway. That particular wallpaper, just so you know, is in the Victoria and Albert Museum in London. They're fabulous interiors. And then the dining room, we think, we're not sure and we can't prove it, may be among the first rooms in colonial America that was done in the chinoiserie style. So right now, we're exploring that, but it definitely was among the first in colonial America. And then here is George Mason's study, where a lot of what he wrote happened, not everything, but quite a bit, and where he sat and entertained a lot of guests, from Thomas Jefferson, George Washington, James Monroe, and so forth. And I encourage all of you to come and visit and see for yourself the magnificent, in the hallway, there's that incredible carving that hangs down in the middle. The carvings by William Bernard Sears are incredible. So I urge you all to come and take a tour. We have guided tours of the house. So, and it's also it doesn't look it, but it's also very family friendly because we won a grant from the IMLS to experiment with various things for when we have families in the house and how we can engage families and their children more directly in history within the mansion. So please bring your families. Second slide. And In October of 2023, Gunston Hall opened its restored Riverside Garden, 1-acre garden. There was extensive archaeology done to bring it back to pretty closely how Mason had it. The fence that you see around it in the background probably was not there. There was a type of fence, but not the type of fence that we have there now. But it pretty much has been pretty faithfully restored, along with some heirloom seeds. So we grow a lot of it. We're also a NABA certified butterfly garden. And when you walk out to the end in this particular slide, and you see those gates way out there, you look way down to the Potomac, and if you look at the slide of the Potomac over there, it doesn't quite show it, but that was a deer park during Mason's time. And at the end of that gate, where that picture was taken from the Potomac, are terraces, and we think, we're not sure yet, but we think that he may have used that for a hunting platform down into the deer park. We're not sure. So, and we have a lot of very interesting ongoing archaeology going on. We have the ECR project where we're going to be using the archaeology to help reconstruct some of the quarters of those who were enslaved on the property. And that would be, if you, going back to the first slide, thinking to the left of that mansion, that's where we have found archaeological evidence of the enslaved quarters. There was also another grouping of enslaved quarters, but we haven't found them yet. They're about 150 yards away. We're somewhere closer to Gunston Road. We're just not sure where it is yet. So, but we are extensively investigating all of this at the time. Let me see, what else? Okay. I also would like to say, don't miss our exhibit, Revolutionary Rights. It's where we detail George Mason's intellectual development and his lasting legacy, and his influence, particularly on the France's Declarations of Rights of Man and Citizen, which was quite extensive. And then, if I may, I'd like to just briefly talk about our events that are coming up. May 9th, we have our very well-known Cocktails by Candlelight, where we serve 18th century food and cocktails, much of it harvested from our historic garden from heirloom seeds. So that's always quite the event, and sells out. So if it's something that you're interested in, I would say go to the website and get your tickets. May 17th is our fundraising gala, and June 14th is one of our big events of the year. This June 14th, this will be our Declaration Day commemoration of the 249th anniversary of the June 12th, 1776 Virginia Declaration of Rights. Free event. Again, I thank you for the opportunity to publicize Gunston Hall, and we hope you make use of your complimentary admission passes. If you have any questions, please do not hesitate to contact me or Kate Steer, our senior curator. But you can also ask me questions here now, too. So, sorry. So, any questions? Okay, great. Thank you.
Thank you, Sandra. How many of you have been to Mason Neck? Aha. When you were driving there, were you saying, I feel like I'm going to another state? Alexandrians, particularly, I mean, Fairfax County is kind of big and weird and lumpy to get around in if you're an Alexandrian, but going to Mason Neck feels like West Virginia. I know. I was an Alexandrian. Now I live on the Neck. George Mason has been called the forgotten founder. He's so forgotten that I remember a few years ago when George Mason University was vying for the basketball championship, the sports announcers were saying, who the heck is George Mason? Only earlier today, a 20-something-year-old in the gym who goes to George Mason University, and I said, we're having a lecture on him. She said, who is that anyhow? So, forgotten, forgotten, forgotten. However, I think of George Mason at least twice every day because I drive past Gunston Hall, on Mason Neck, past Mason Neck State Park in order to go to my home. Not quite as palatial as George's. But as I drive past and I see the entrance sign, and in I think it's June, when the laurels are blooming most magnificently in the entrance, I'm very thankful that this has been preserved by the Commonwealth of Virginia and the colonial dames for this property, which I think is magnificent. You can also get a very inexpensive pass to walk the grounds, miles and miles of beautiful trails, as there are all throughout Mason Neck. So I'd like to invite you to Mason Neck State Park, the U.S. Federal Wildlife Eagle Preserve, the Bureau of Land Management, Meadowood, the Northern Virginia Regional Parks, the golf course, and the park. Half of Mason Neck is publicly owned and is the most protected and preserved habitat in Fairfax County in terms of its whole size. So I hope you'll visit us, and particularly after you hear what John Rand has to say. Dr. Rand, newly doctored last year, as he was beginning his retirement from 40 years of practicing law in Alexandria, he decided he just needed a few more things to do in his life, take on a dissertation topic. And by talking to his advisor, came up with the 10th Amendment. John completed his dissertation. I've read 2 chapters, which I think are very, very fascinating. And I think you'll find it fascinating, too. Just to remind you, in terms of his overview, the 10th Amendment to the Constitution has been controversial throughout American history. Most recently, it's been a favored vehicle on the part of conservatives to reduce the size of federal government on the basis that the 10th Amendment requires that states retain all powers not specifically delegated to the federal government. At other times, it's been used to justify slavery and racial segregation, as well as to combat a variety of liberal labor and economic laws. George Mason was the first to propose the elements of the future 10th Amendment in the Constitutional Convention of 1787. He's given credit for his role in the Bill of Rights, but rarely recognized for his more favored amendment, the 10th. His original intent concerning the 10th Amendment connects Mason with the history of slavery, states' rights, civil rights, and the scope of power of the federal government. I'm fascinated. So here's Dr. Rand.
Thank you, Pam. I'll try to master this microphone.
I just want to advance this one for you. Okay. There you go. There it is.
I'm only getting used to being called doctor, which I don't like. I think doctor should be for people with medical degrees. I'll never call myself doctor. But I do want to enthusiastically recommend Gunston Hall. It's really a jewel down on Mason Neck, and you can't go wrong going for a visit. So I would say that they've just done fabulous work in terms of their new garden, their focus on the enslaved interpretation, the just everything about Gunston Hall is excellent, and so I'd recommend it. The 10th Amendment. So, as Pam said, the 10th Amendment has been controversial throughout our history. It's been the subject of a lot of contemporary angst for the last 50 years when conservatives have been challenging federal laws as being too all-encompassing for the federal government, because if you read the Constitution, the states are supposed to have certain powers that are not specifically delegated in the Constitution to the federal government. it's a pretty flexible constitutional amendment because recently we've heard talk about the current administration wanting to take certain actions in states that people begin to say, well, is the federal government really supposed to be fooling around with congestion, traffic congestion in New York City, for example? Isn't that a state issue? I want to say, oh, the 10th Amendment. Let's talk about the 10th Amendment. So to understand Mason's connection with the 10th Amendment, we have to go back to Mason's time. By the way, Mason had plenty of connections to Alexandria. Mason was originally a justice of the peace when he was young in Alexandria. Alexandria was essentially the county seat for Fairfax County. He also had issues with Alexandria. There's plenty of research concerning how he had certain battles with over tax issues and other things with Alexandria, county versus city sort of thing. So that would be the subject of another talk, I'm sure. So going back to let's go back to the American Revolution when we still had colonies. The colonies, that's 1775, the Revolutionary War had started already in Massachusetts in April of 1775. The colonies sent representatives to Philadelphia to see if they couldn't coordinate some sort of action regarding Great Britain. And it wasn't any sort of sanctioned national government, but it was a work in progress. The Continental, they were later called the Continental Congress, but they went back to the colonies and they said, well, the royal governors have all left. They didn't want to get tarred and feathered or whatever else was happening to them, and we would recommend that you consider writing constitutions and becoming states. And that happened. George Mason, as a matter of fact, was principally responsible in 1776 for writing the first Virginia Constitution. And the Declaration of Rights that Sandra referred to was a preamble to that Constitution that occurred in June of 1776, and it was actually used by Thomas Jefferson when he wrote the Declaration of Independence a month later. So that doesn't have anything to do with the 10th Amendment, but it's just an example of what a outstanding intellectual and politician George Mason was. He was one of the oldest founding fathers and one of the most important, and certainly one of the most forgotten founding fathers. So at any rate, the point is that the states began to write their constitutions, and there was no national government, so the states were first. That's why at that time, the most men's loyalty, and there were women, but of course women weren't allowed to participate in the public sphere at the time. But that's why loyalty was to states. When Mason wrote several years later about what was happening in the Constitutional Convention, he spoke about having acted in the best interest of his country. And when he said his country, he meant Virginia. He didn't mean the United States, even though at that time there was a national government. So when the Continental Congress was engaged in the Revolutionary War, they began talking about what sort of government they could they could establish, and they decided to have a loose confederation, which they did call a confederation. It was to be governed by what they called Articles of Confederation, but those articles did not actually get adopted until almost the end of the Revolutionary War in 1782, and the reason for that was that Maryland objected. Maryland was unhappy about other states having claims to Western lands, and Maryland didn't have those claims, and they refused to agree to it. And there was a consensus in the Continental Congress that all the states had to agree in order to have the Confederation. So that's how the Northwest Territory got formed. And once that issue was resolved, then the Articles of Confederation were signed and adopted by all the states, 1782. So it's a very interesting period of American history. I think that most people don't even understand that there was an actual national government before the Constitution. It wasn't a very successful government, which of course is why we ended up with a Constitution. But what happened was that not only did all the states have to agree, which is difficult, but the Articles of Confederation did not give the government much power. They didn't give the government the ability to tax the states. They had to ask for contributions. They had no enforcement provisions. So it was a very weak government, and things were not going well, so that several of the leading men, whose names I'm sure you know, James Madison, Alexander Hamilton, they wanted to create a stronger government, which was very difficult because you were asking those who had power in the Confederation Congress to give up that power and create a different kind of government, which was difficult. So they tried for several years, and finally managed at a meeting in Annapolis where they had a bare quorum to have an agreement to meet in Philadelphia in the summer of 1787 to amend the Articles of Confederation. So when they did show up in Philadelphia, James Madison had done a little bit of legwork and showed up with what has been called the Virginia Plan, which is essentially the framework of what became the Constitution that we have now. Madison gathered all the delegates from Virginia, which included George Mason. George Mason, by the way, had never traveled outside of Maryland and Virginia, so it was the first time that he had ever traveled that far. But he was very interested in participating because he understood that they were laying the groundwork for something that was very important and very permanent. So he went to Philadelphia as a delegate, and he met with the Virginia delegation. They all arrived before everyone else, and they all agreed that they would support this plan of Madison's, and proceeded to work all summer long in 1787 to write a constitution. It wasn't easy because there was a lot of disagreement. Even though all the delegates were essentially elite men, they had a lot of disagreements, as you can imagine. And as the summer went on, George Mason in particular became very dissatisfied with what was going on. One of his largest concerns had to do with individual rights and he felt that the new Constitution needed a Bill of Rights. It didn't have one. The reason it didn't have one was because the other delegates at the convention felt that the state charters that were then in force were sufficient, and they didn't want to go down what they considered a rabbit hole that as to what would be an individual right and what wouldn't be, and they felt that the state charters would still be in force. Mason argued that if the Constitution, as it had already been thus far drafted, had a supremacy clause that stated that federal law would be superior to state law, then the state rights charters would not be enforceable. He brought a motion before the Constitutional Convention. He got the support of only 2 other men, and it went down in flames. So by the end of the convention, Mason was quite dissatisfied, and why he was so interested in individual rights is difficult to say. He had written the Declaration of Rights, which was a document that was before its time and was lauded by so many people, and so he had a reputation in a way. He was older than some of the other founding fathers, and a little bit more set in his ways, I would say. And some people would call him a bit of a curmudgeon, but he was a very intelligent, very principled, very consistent man, and he really did have a respect for the rights of individuals and not just the elite. In some respects, the other delegates at the convention had less of a concern for other Americans, the middling class, so to speak, the lower class, middling class, and there were the elites, and they represented the elites. So it wasn't that they were as concerned about their own rights as they needed to be, because their rights were taken care of. But at any rate, Mason was one of 3 delegates not to agree to sign the Constitution as it came out of the convention. It didn't need to be signed. It was basically a draft that was being forwarded to the Confederation Congress, hoping to get the Federation Congress to recommend it to the states for ratification. They had very wisely written into the Constitution that it only needed to be ratified by 9 states instead of all the states, which was an obvious a need for them, since Rhode Island didn't even bother to come to the convention. Rhode Island was not interested in a stronger national government. So Mason refused to sign it, and he was the first to write on the subject. He wrote an essay that he titled Objections to the Federal Constitution, and the very first objection was that it lacked a Bill of Rights. And in those days, the way you got your message out was through writing essays and being published in newspapers. And what happened after the convention was what we call the ratification period, which was a period of 10 months that the states all considered it. They all had conventions at different times, and they considered whether to ratify the Constitution or not. It's another interesting period of American history that doesn't get a lot of attention because most people think that everybody was in favor of the Constitution, and that's absolutely not true. Scholars that study this period will tell you that approximately 52% of the American public at that time opposed the Constitution. The problem was that they were concentrated in certain states, and particularly New York, Rhode Island, North Carolina, and those who supported the Constitution were called Federalists, and those who opposed the Constitution were called Anti-Federalists. The Federalists had the votes in sufficient number of states to ratify the Constitution, which occurred 10 months after it came out of Philadelphia. So the role of George Mason in ratification is extremely important. He was probably the most well-known leader of the anti-federalist opposition. He was published in more papers than any other anti-federalist writer. He was the first to suggest that the Constitution needed a Bill of Rights. He has been known since as the father of the Bill of Rights, even though he didn't write the Bill of Rights. James Madison wrote the Bill of Rights. And during the ratification campaign, he also suggested that we needed something that was similar to what is now the 10th Amendment. With almost the exact same language, he suggested that because of the danger of the federal government being too powerful, it should be limited only to those powers that are listed in Article 1, Section 8 of the Constitution, that delegates certain powers to the federal government, and all other powers should belong to the states. So not only is George Mason the father of the Bill of Rights, but he's the father of the 10th Amendment, or the originator, at least, of the 10th Amendment. So after ratification, what happened was we needed to fill the federal offices, and the Constitution was ratified by 9 states in June of 1788, and in the fall of 1788 and the winter of 1789, there were elections for federal offices. In Virginia, the legislature was controlled by the Anti-Federalists. The vote in Virginia was fairly close. Virginia was considered to be equally divided. A fascinating story about the convention, the ratification convention in Virginia. There's some excellent books on that. And Mason and Patrick Henry were the two leaders opposing the Constitution at the Virginia Convention. But sorry, I lost my train of thought here. We were talking about the running for offices, and the legislature in Virginia was controlled by Anti-Federalists, even though the vote was pretty equal. And in the new Constitution, the state legislatures were enabled to appoint the 2 senators for each state. They first offered George Mason one of those positions, but he declined. He had been very bruised, so to speak, in the ratification battle. The Federalist Papers had really taken off after Mason, and said many scurrilous and untrue things about Mason, and his reputation was pretty much in tatters after that. It was because it was such a close vote, in many states, it was very antagonistic. So he wanted to retire. He was not well. He actually died within 4 years in 1792, but he retired to Gunston Hall. James Madison wanted to be a senator from Virginia, but there was an anti-Federalist legislature, so he didn't get the appointment. And James Madison decided to run for the House of Representatives from one of the 7 congressional districts where he lived in central Virginia, which was a very tough race, being evenly divided. He ran against James Monroe, who was a young anti-Federalist at the time, later, of course, to be president. And Madison saw the handwriting on the wall, and he heard the message that people wanted a Bill of Rights, so he agreed in writing that if he was elected to the House of Representatives, he would, one of the first things he would do would be to propose a Bill of Rights to amend the Constitution in the new Congress. So he did win. In February of 1788, he won that election by 300 votes, pretty close election. And when he got to New York, later that spring for the first Congress, one of the first things he did was he proposed a Bill of Rights. And it's pretty similar to what we have today. All but the 10th Amendment are individual rights, freedom of religion, free speech, freedom of the press, that sort of thing. But there's the outlier is the 10th Amendment, which of course has to do with the division of power between the federal government and the states. The Congress, the first Congress, was roughly 2/3 Federalist. By that time, people were sick of the bickering, and they saw the new Constitution as a big benefit to economic stability, and Federalists were elected primarily to further that goal. So when Madison proposed a Bill of Rights, he proposed something that was non-controversial. He had to rely on Federalist votes to pass it, and who doesn't want individual rights, right? That's what we fought the Revolution for. But the interesting thing is that the 10th Amendment was not controversial either. At that time, as I mentioned before, there was a great allegiance and loyalty to one's individual state, and all the delegates of the convention assumed that they were writing a constitution that would have a specific role for the federal government, primarily in foreign affairs or adjudicating disputes between states, but most of the grunt work, so to speak, would be done on the state level and not on the federal level. So that was why the 10th Amendment wasn't controversial at the time. The problem was that throughout the history, long before the Revolution even, and even up to the current day, we've had a division in our society that has, it's tough to say exactly what it is, but sometimes it's a division between rich and poor, between haves and have-nots, between now we see it between liberals and conservatives. Back then, the very first terms that were used were between cosmopolitans and localists. So cosmopolitans in the colonial era were more geared toward a market economy and whatever urban areas there were then, and localists were rural agricultural people. So when we got into the 1790s, in George Washington's first administration, there was still this split and this division, and it was demonstrated by Alexander Hamilton, who wanted to develop an economy that was based on a mercantile and capital, and we had Thomas Jefferson, who wanted to emphasize agricultural yeoman citizen sort of philosophies, political philosophies. So as soon as we essentially got out of the starting gate, there was big controversies over the 10th Amendment, which seemed to be so non-controversial when it was passed. And one of the first things was the National Bank. Hamilton wanted a national bank. Jefferson didn't want to have a national bank. It didn't actually reach the Supreme Court till the early 1800s because it required the Supreme Court to decide that they got to adjudicate all constitutional issues. That wasn't the original intent of the founders for the Supreme Court. But by the time John Marshall, who was an ardent Federalist, took control of the Supreme Court, he got the case on the Second National Bank, and his ruling was, well, yes, the Constitution delegated these specific powers to the federal government, but there was this clause underneath that section that said, and the Congress shall have the power to do whatever is ever necessary and proper to implement these delegated powers. And that's called the necessary and proper clause. And basically, in Marshall's view, it enabled the Congress to decide that they would have whatever power they needed in order to implement their delegated power. So if they had a delegated power where they were in charge of the national economy, then they had the right to say that they needed a national bank to implement that. Whereas those who believed that national banks were a problem argued that the 10th Amendment didn't allow the federal government to do that, that the 10th Amendment said that was a state province. And there were state banks at the time. Just the Federalists thought that they were corrupt, and the Anti-Federalists thought that the Federalists were corrupt. So it's all, it all stays the same. We have these divisions that just keep on going. So essentially after that decision on the Second National Bank, the 10th Amendment looked like it was dead in the water. But how are we doing on time?
You got time.
Okay. So we went on with the southern states. Southern states loved the 10th Amendment because they said, well, the Constitution doesn't say anything about the federal government having the power to prohibit slavery from the territories or from new states, or even, God forbid, doing away with slavery in the South. The states have the right to decide that issue, and when it came to seceding from the Union, they used the 10th Amendment as their rationale for seceding. They said, we have the power to make these decisions, and the federal government doesn't have the power, and they're trying to do something that's unconstitutional. So we're just going to take our states and leave. 10th Amendment was involved in other racial problems during Reconstruction, after the Civil War. The Republican Congress passed laws that enabled blacks to use public transportation, for example, conveyances and whatnot. And after Reconstruction, that was challenged, and the Supreme Court and this is always in the Supreme Court because it's a constitutional issue. The Supreme Court said no. The 10th Amendment says that you can't do that. The states have the right to decide what their laws are going to be. The 13th Amendment did prohibit slavery, but it doesn't deal with issues about private conveyances and whatnot. So we let the states decide that. Moving into the 20th century, the 10th Amendment had a large role in almost every economic issue. When the Congress tried to prohibit, for example, child labor in states that allowed their children their 12-year-old children to work 10-hour days, 6 days a week, the Supreme Court said, no, you can't do that because it's unconstitutional, because according to the 10th Amendment, the states can decide what they want to do, and that isn't necessarily in interstate commerce. It became a question of another clause in the Constitution, the Commerce Clause. When it came to the Great Depression, Franklin Roosevelt decided that he needed to nationalize the economy, have wage and price laws, have the Economic Recovery Act, the things that would nationalize the economy so that nobody was destroying his effort to climb out of the Depression. But the judges on the Supreme Court said no. The 10th Amendment prohibits that. You as Congress can't tell the people of New York how to price their eggs. That's up to the state. That brought on Roosevelt's plan to add justices to the Supreme Court because he was unhappy with what he was getting, the so-called court packing plan. But thankfully for Roosevelt, those men who had been there for many, many years began to die and resigned from ill health, and Roosevelt got to appoint his own justices and got what he wanted. So their rulings in 1937 essentially decided that the 10th Amendment was dead, and there were no 10th Amendment cases for 30 years until Nixon appointed conservative justices to the Supreme Court, and in 1975 they managed to invalidate or I should say find as unconstitutional one of Nixon's favored laws that he got the Congress to pass on wage and price controls. And they used the 10th Amendment to say, no, you can't do that. The federal government can't tell a state what to pay its own employee. That's in violation of the 10th Amendment. So for many years since 1975, I would say there have been 2 or 3 10th Amendment cases before the Supreme Court, and by and large, the court has been fairly conservative and has found that the 10th Amendment has considerable viability, and therefore the federal government has to watch that it doesn't intrude on state prerogatives. So that's where we stand. The question, I suppose, is what would George Mason make of all that? Certainly, I think he'd be appalled that there are these diametrically opposed interpretations of the 10th Amendment throughout the history of our country, depending on the political positions of the Supreme Court justices. But moreover, I think that Mason would say what's important is the individual rights issue. He'd probably be pretty amazed, as most founding fathers would, all founding fathers would, I'm sure, at the technological changes that we've seen. In his day, it took a week to get to New York, so of course he believed that the federal government would be a problem for anyone seeking their individual rights in Virginia, because the federal government was so far away. Mason was a localist. Now, of course, you can get to New York in a couple hours, and we have instant communications. So I don't think that he would find that to be as much of a problem. And I think, moreover, if you look at the last 100 years of our history, you would find that the federal government has been far more protective of individual rights than states. You're talking segregation, you're talking Brown versus the Board of Education, you're talking about the enhancement of individual liberties in the Warren Court. There's a dozen different instances that I can think of, and Mason was not an iconoclast. He didn't believe, like some, that you have to interpret the 10th Amendment strictly on the basis of its text. He had reasons for wanting to have a 10th Amendment that involved underlying considerations. And so I would say that, in the last 50 years, I believe that there have been Supreme Court opinions that have mentioned James Madison as supporting a position to uphold the 10th Amendment and find congressional legislation to be unconstitutional. But I would think that if they would look a little further and consider what George Mason thought, we might have a different result. So that's a brief history of the 10th Amendment and George Mason, and perhaps someone wants to make a comment or start a discussion or ask a question.
I have a question.
Sure.
So the state of Florida is considering child labor laws, reviewing those because of the lack of workforce due to...
I'm sorry, I can't hear you. If you could speak up a little.
The state of Florida, can you hear me?
Yeah.
The state of Florida is reviewing their child labor laws as a result of a reduction in workforce due to the immigration enforcement. Does this play into the 10th Amendment as far as the rights of...
Well, yeah, I mean, the 10th Amendment essentially says the states should have the right to decide their own laws concerning labor, but child or otherwise. But the problem is the Commerce Clause. So one of the delegated powers given to the Congress in Article 1 is that they should have power to adjudicate issues of interstate commerce. So so if you look back at the Constitutional Convention, the question is, well, what is that? How do you define that? There's some reason to believe that it only meant when the states have a difficulty with one another and the federal government needs to adjudicate that. Some interpret it as being anything that has to do with any sort of interstate commerce. If it touches interstate commerce, then the federal government can get in and be a part of that. So it depends so much on the Supreme Court. That's why I keep talking about the Supreme Court, is that every time there's a case involving the 10th Amendment, it's always in front of the Supreme Court. So there was a series of cases not too long ago about marijuana laws in California about whether that was a federal concern, that since it affected other states, this was before marijuana started to become illegal, whether it was about medical marijuana in California, whether that, to allow medical marijuana in California was okay, or whether the feds had the right to go in and say, no, you can't do that because it affects other states where marijuana is outlawed. So it's up to the courts, really. I can't predict whether Florida could have the right, but in this day and age, I don't think you should have child labor laws that let kids work to excess, if that's what you're suggesting they want to do. I wouldn't be surprised. Coming out of Florida, I wouldn't be surprised about anything. But any other questions? Yes?
I didn't grow up in Virginia, and I've been studying since I've moved here about the Dillon Rule. Now, is this some type of converse? And when was the Dillon Rule? Was that? I have no idea the history of it.
Can you repeat the question?
The question is about the Dillon Rule. It has nothing to do with the 10th Amendment. The Dillon Rule has to do with the power of the state to interfere with cities.
If it's not specifically enumerated, there's a power to the cities, then the state. You cannot do it. When I first moved here, the fact that there's no prohibition on cutting trees.
Yep.
So I spoke to someone, they said, oh, Dillon Rule, you can't do that. Everything, I was like, really?
Yeah.
It's almost like a converse of this.
Okay. Well, I see where you're going with it in terms of state versus local and federal versus state. I don't know that much about the Dillon Rule, but it's an unusual rule, I think, where localities don't have as much power in Virginia as they do in other states. Yeah, I think that's what you're getting.
I just wonder if there was any type of, if there was any connection.
No, not that I know. Not that I know. Wow, that was a tough one. Yeah, go ahead.
Thank you for walking us through the Testament. Could you tell us a little bit more? Actually, first, I was surprised that Jefferson wasn't the most fervent anti-federalist.
Jefferson spent the entire ratification and convention time in France, so he communicated all the time with his buddy James Madison, but he was kind of hands off.
But was he as strong as anti-federalism as Mason or?
Yeah, he and Mason were friendly. But he didn't really get actively involved. But Jefferson, when he came back and got into Washington's administration, was as strong an anti-federalist as anybody. He was a very strong and potent character. But it stopped being called anti-federalism. It began to be called Jeffersonian republicanism. But it was essentially the same thing. But that's a good question.
Thank you. I wish to know, so back then it was very interesting that, first Mason wrote the Virginia Declaration of Rights.
Yep.
And months after, Jefferson pretty much wrote the same thing in Philadelphia.
Right.
And this, there wasn't intellectual property, but could you explain to us, between Mason, Jefferson, who did which part towards?
What their relationship was? Well, Mason was older than Jefferson, and they were not good friends. The most interesting thing is that Mason was neighbors with Washington. George Washington was a very ardent Federalist, and they fell out because of the whole convention and ratification, and they never spoke with each other again. They were formal, but they had no relationship after that. Jefferson was friendly with Mason, but he was a lot younger, and Mason was a lot older. Jefferson used some of Mason's Declaration of Rights, but with permission, I think, and it wasn't, plagiarism or anything like that. It was just that Mason came up with it first, and it was good stuff. And he was writing the Declaration of Independence and saw something that he wanted to use, and it was okay. So it wasn't, they were on the same page, if that's what you're asking.
Like back then, traveling was very difficult. How, like waiting a month? So Jefferson probably had a copy of the Virginia Declaration of Rights.
He did. Yeah, he did. Yep.
Okay. And then Madison also, like, pretty much copied from him.
Well, you're right. I mean, that's a good point. Everybody copied from everybody else, from Locke on down. And there was a general consensus, political, philosophical consensus. Interestingly, that's one of the reasons why they were afraid of a federal government, because the political philosophy at the time was that no republic could be successful with such a large country, that successful republics were small. I guess they proved them wrong. Question?
Yeah, I have a question about the ratification politics, which you went into a little bit. So
Yep.
the leading advocate in favor of ratifying the Constitution was Madison, and the leading opponent was Mason. And then Madison switched sides. He said, well, if we're going to have this thing, I'm going to write it, because he was a control freak. I'm wondering what your thoughts on if George Mason had written the Bill of Rights, what it would have looked like.
Well, yes. The question is, if Mason had been able to write the Bill of Rights rather than Madison, what would it have looked like? But I wouldn't say Madison was a control freak. In order to get elected, he really had a strong desire to be involved in the government, and he wanted to be elected, and he saw the opportunity to write a Bill of Rights. Number one, it would be non-controversial. It had to be in order to pass. But also he saw it as a way to reach out to anti-federalists and try to get them to be more amenable to the new government and what he had in mind, and get everyone happy again, because it was quite a nasty fight during ratification. But if Mason had written the Bill of Rights, it wouldn't have been like that at all. There were other things in the Constitution that he didn't like, and that most anti-federalists didn't like, and that primarily involved the ability to directly tax people, the ability to have a standing army, other measures that we might associate nowadays with conservatives. Actually, Mason was more of a status quo kind of guy. He kind of liked the way things were, and he was afraid that here was this big experiment that had never happened in the world before, that America was undertaking, and he was worried that this was going to go wrong and this was going to go wrong, and when he did look at the Bill of Rights, and there's a letter that he wrote that in which he comments on it, and he basically said, well, yeah, that's pretty good, but they needed to do a few other things, and one of the things, if I recall, was he didn't like the idea of the federal judiciary, and he didn't like, I can't remember the other things, but they were things that weren't in Madison's Bill of Rights, which was very non-controversial, because everybody had to agree to it, and like I said, who would not agree to individual rights, because that's what they'd fought the revolution for. Yes, I'm gonna let someone else ask a question back here. Yes.
This is a small point, but I'm just curious. Who are the two other people besides Mason who didn't sign the
Okay. Well, Virginia, the governor of Virginia, I want to say Randolph, but that's not quite right. Pardon? No, he wasn't a delegate to the convention. What's his name from Massachusetts? See, I know them, but my 70-year-old brain is not bringing them up. But the fellow from Massachusetts and the current governor at the time from Virginia, who changed sides when they had the Virginia ratification. I think it was Randolph is what I'm thinking, but when they had the ratification convention in Virginia, he changed sides and regretted that he hadn't signed it. But I'm having a mental block, I'm sorry. But there weren't many, yes.
So just to close the loop on the federal minimum wage, you said during the Nixon era, it was struck down pursuant to the 10th Amendment, but then we do have a federal minimum wage. Was that due to the Commerce Clause?
No, it wasn't the federal minimum wage. It was a law, the 1975 case, the famous case that Rehnquist wrote the opinion for. It was Nixon's wage and price controls where he wanted to tell the states that they couldn't pay overtime to state employees because then they would be making more than the federal employees, and therefore it would cause, in theory, inflation to spiral out of control. And the court decided that was a bridge too far, and that was a state responsibility to decide what they should pay their own employees.
Had there been an argument made for the 10th Amendment for a federal minimum wage at some point?
I don't know. That's a good question.
And sorry, a follow-up question regarding the...
But that would apply to federal, I assume that would apply to federal, anything that was federal. So the Congress can make laws that apply to all the federal institutions and the federal...
Sure, but you haven't...
And states, I think, have their own minimum wage laws, so...
Usually above the federal minimum wage,
Yeah.
not below. Right. So, and the marijuana law for California, what's the current status of that?
Well, marijuana is, at the time they had those 10th Amendment cases, California had medical marijuana where you could grow it and use it and whatnot. And the feds passed a law saying you can't do that. And there was a lot of angst on the Supreme Court about whether that would be okay to have California do that under the 10th Amendment because it was a state function, and on the other hand, whether having medical marijuana in California affected all the other states and therefore was it permissible.
It was permissible.
Well, yes, actually I'm trying to think of the year. I'm trying to think, that was in the teens somewhere before everybody started to have marijuana.
No problem, because you could smoke dope in California, but you couldn't have it like on an
Yeah.
airplane. You don't get your jurisdiction.
So it just goes to show how important this particular issue is, the division of authority between the states and the federal government. And it really goes under the radar a lot. Yes, sir.
The very last clause there, it says, or to the people. Your talk, which is, I think, terrific, has been, state versus federal. What does or to the...
That's a really good question. That was added in the Senate version when this went through the Congress in 1789. That clause was added by the Senate, and the story supposedly was that it was done by Federalists because they had justified being able to have the new Constitution based on the fact that they had the power, instead of the states forming the Confederation and therefore needing permission of the states to have a constitution, the Federalists claimed that they had the power of the people to do a constitution and to do whatever they wanted, basically, to flout the fact that it was the states who had entered into a compact to have a confederation. So supposedly the Senate added that to justify their political theory that all power came from the people. But it's come up since, and in an interesting Supreme Court opinion by Clarence Thomas, of all people, he cited that and said that means that not only can this power needs to go back to the states, but the people of the states get to vote and decide what their power should be. It was really completely off-the-wall legal theory from Clarence Thomas, and nobody's ever touched that with a 10-foot pole. But it's just kind of hanging there, and nobody really knows what it means. But every legal analysis of the 10th Amendment has pretty much ignored it and just says this is a question of whether the federal government has the authority to do something or whether the state governments have authority to do it. So, good question. Yes, who hasn't asked a question? Here we go.
When the 10th Amendment was adopted, we had a very different economy. And now we have an international, federal economy. Has there been any time in the last 30 years when the Congress expressly exercised its authority under the Commerce Clause and says it's essential for interstate commerce that has been struck down under the 10th Amendment? Or is it, is it how we adopt these rules? So as distinguished from, say, a president unilaterally issuing a regulation?
Wow.
Restate that.
Well, there is, of course, always the problem of a president thinking that he can do whatever he wants. But I can't really answer your question. The 10th Amendment comes up only in several cases every year, and it's been very low-key ever since the conservative Supreme Courts, Sandra Day O'Connor, Clarence Thomas, Rehnquist, and two others formed a 5-4 majority for a number of years in the 80s and 90s that ensured that any time that the 10th Amendment was brought up, that they would vote for it. And so there's a series of cases there, and it hasn't really popped up a lot since then. But it might be because the Congress has become so ineffective that they don't seem to try to enter that dynamic anymore. And Republican Congresses don't try to exercise as much authority over everything. But it always is a Supreme Court issue, with one exception. In the 1990s, Senator Ted Stevens tried to pass a law that said every time Congress passes a law, they have to consider the ramifications of the 10th Amendment. It died in committee.
Thank you, John.
All right.
I think there's an audience with rapt attention. Thank you. And I wanted to let you know the U.S. Capitol Historical Society has a whole set of videos on every amendment, and they're really interesting to look at. You can get on their e-news for free, but just look up U.S. Capitol Historical Society amendments, and you'll see their YouTube station. Very, very interesting by a variety of scholars. Thank you. See you at Michael's tour on Saturday the 5th and next April. So thank you so much. Good night.